Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing Thursday. Hey, if you was with us last night on live with the Jay-Z versus Tony Buzbee lawsuit, you have missed it. You have missed it. Come to find out, not only did Tony Buzbee send a demand letter to Jay-Z regarding Jane Doe, but also a John Doe. If you have not peeped out that live, you need to tap in. It will be included in the Tony Buzbee versus Jay Z list or Jay Z versus Tony Buzbee. It's one of those. Check out the playlist, get the scoop, don't be behind. Anywho's, Tony Buzbee has not came to play in 2025. He's hitting Jay-Z, Rock Nation, and Diddy on all sides. Do you hear me? On all sides. I just found out. Shout out to Megan Conniff. She usually covers a lot of stuff that goes on in LA, and she gets doxxed when can't nobody else get doxxed. And I like her. She using her journalistic card. Okay, so these are the two notices of appearances that have been filed as of yesterday to represent Jane Doe as well as Tony Buzbee in the Jane Doe versus Diddy and Sean Carter case. All right. Why are attorneys coming in? I'm going to explain that in a minute. But I want you guys to pay attention as to who this firm is. This is Casowitz Benson Torres LLP. These are Trump's go-to lawyers. And the fact that Tony Buzbee has connections with Trump and his team, that's mind-boggling. All I gotta say is, hey, it's about to be a very eventful 2025 when it comes to these Diddy cases and Jay Z cases. So, Mark and Veronica. Let me see. Let me go back to the first one. So it reads that please take notice that Mark P. Wrestler of the Castlewitz Benson P. an attorney admitted to practice in this court, hereby enters an appearance as counsel for plaintiff Jane Doe and for plaintiff's attorney Anthony G. Busby in the above captioned action and respectfully request that all further papers and correspondence be served upon him. So Mark has entered the chat as well as another attorney, Veronica Alayeva. All right, so this is Trump's go-to firm. They've represented him in cases like the Russia investigation. These people do not play. And when I say these people, I'm talking about the law firm. They do not play. Shout out to Megan for getting these documents. So, one comment or on her post she made is she stated that it's not uncommon for plaintiffs to get more lawyers, but I'm not sure I've seen the lawyers also represent another lawyer in a case. Let me explain why this is happening. We have two things that are going on in the Jane Doe case. One, Alex Spiro is trying to get that First Amendment complaint naming Sean Carter dismissed. That's number one. On the other note, he is also trying to get sanctions ordered on Buzbee. Alex Spiro has claimed that Buzbee did not do his due diligence in vetting Jane Doe and her claims. Therefore, he violated Rule 11 of the Federal Rules of Civil Procedure. And when you do that, that calls for sanctions. He also has stated that Tony Buzbee has not even sought admission into the Southern District of New York. Again, that is a violation of Rule 11 of the Federal Rules of Civil Procedure. So, in that alone, he has to have representation. Tony Buzbee has to have representation to pretty much fight. So, it's like its own case within a case, if that makes sense. Okay. Now, so shout out to Megan for getting us those documents. Now, what I want to divert your attention to is the actual opposition that was filed by Tony Buzbee as well as his declaration. So he is opposing the motion for sanctions. Now, I'm gonna go backwards because I'm gonna read the declaration first, and then I'm gonna go and I'm gonna read the memo so you guys can understand. I am an attorney duly licensed and in good standing in the state of New York, the state of Texas, and the United States District Court for the Eastern District of New York. My application for reciprocal admission in the Southern District of New York is forthcoming. I am the principal of the Buzbee Law Firm, a respected law firm based in Houston, Texas. I and my firm represent plaintiff Jane Doe in the above captioned action. I have decades of litigation and trial experiences in courts around the country and have received numerous recognitions over the years for professional excellence, including being named Attorney of the Year by Texas Lawyer. I submit this declaration in opposition to Defendant Carter's motion for sanctions under Federal Rule of Civil Procedure 11. Now, counsel's investigation of plaintiff's allegations. So here he's going to explain what he has done in order to vet his plaintiff, aka Jane Doe. In 2024, I and my firm became involved in the civil claims arising from the revelation that the world famous rapper and music star, defendant Sean Combs, more commonly known as Diddy, was accused of engaging in systematic sexual abuse and sexual trafficking, among other potential crimes, over a period of many years. In early October 2024, Jane Doe was referred to my firm by my co counsel in this action, AVA Law Group, a respected law firm with its principal office in San Diego, California. Now, if you guys don't remember, I told you guys that Buzbee is not the only firm that is doing the intakes. There was a California office that is doing it as well. Go back and watch the videos. I told you guys. At the time of the referral, I was informed by AVA Law that they had conducted an investigation into the veracity of plaintiff's allegations that she had been raped by both Combs and Carter at the VMA's after party in 2000. AVA Law referred numerous cases to us. I was informed that their intake process involved multiple interviews of each potential client, including the plaintiff in this case, including in some cases at least one, if not more attorneys. I further understood that an attorney would interview a potential plaintiff prior to drafting a complaint, as AVA did here. My understanding was that only when the attorneys at AVA Law were convinced the plaintiff's allegations were true and ones that could be pursued did they refer plaintiff to my firm. After plaintiff was referred to me, I and other attorneys at my firm also engaged in other rigorous due diligence to investigate the veracity and legal viability of plaintiff's claims. At least two attorneys at my firm interviewed the plaintiff and fact checked various aspects of her account, among other things, prior to revising and filing the original complaint. Prior to filing the First Amendment complaint in this action, which named Carter as a defendant, my firm undertook additional diligent efforts. These included, among other things, further intensive interviews, which essentially amounted to interrogatories of plaintiff by 3 to 5 attorneys, both alone and in teams, research and verification of numerous details in plaintiff's account, running a background check on plaintiff, and retaining a retired police detective to investigate and verify additional aspects of plaintiff's account. Each of the lawyers within our firm who interviewed Jane Doe have extensive experience and training doing so. Each I trust. At each point in this process, we determined that plaintiff's allegations were credible. It is important to note that I personally interviewed Jane Doe. I found her credible and adamant about the claims she was making. I believe her and still do. With respect to Carter's association with Combs specifically, despite it being widely known that he is a close associate of Combs, my firm conducted additional research to confirm their close connection, which further bolstered our conclusion that plaintiff's allegations against Carter were plausible, credible, and warranted legal recourse. Further, in each of the pre filing interviews, and that I and other attorneys at my firm took of plaintiff appeared both consistent and credible in her account of the night she alleges to have been raped by both Carter and Combs. Commencement of this action. The original complaint in this matter was filed anonymously on October 20th, 2024 against Combs and other defendants, alleging that plaintiff was raped at an after party following the 2000 VMAs on or around September 7th, 2000. As discussed above, before amending the complaint to name Carter as a defendant, my firm conducted substantial additional diligence, including additional intensive interviews specifically regarding her allegations against Carter. On December 8th, 2024, my firm filed the first amended complaint, naming Carter as one of plaintiff's great challenges factual allegations and files his frivolous sanction motions. On December 13th, 2024, Carter filed a pre motion letter informing the court of his intent to immediately file for sanctions and requesting a shortening of the 21-day safe harbor provision in Rule 11. On December 20th, 2024, I submitted a letter in response to Carter's December 13th letter stating that a sanctions motions challenging allegations concerning a child rape victim would be frivolous and would itself be subject to a Rule 11 motion in response. Specifically, I pointed to authority recognizing that a victim who was a minor at the time of the actual assault could not be expected to have exacting recall and command of all relevant facts. Carter filed his meritless sanctions motion on January 8th, 2025, the day after the expiration of the 21-day safe harbor period provided by the Federal Rules of Civil Procedure 11, paragraph C2. Carter's illegal harassment of my firm and clients. Since the initiation of this lawsuit, many past and current employees and clients of my firm have reported being approached and harassed by individuals claim to be investigating me and my firm, urging the clients to sue us. Whew, child. These investigators even contacted my daughter. Several former clients even have been offered money to sue us. We were able to catch the illegal activity on tape. On several occasions, these so called investigators claimed to be working for the state or the feds. I am informed and believe that these so called investigators are connected to Carter and are part of a concerted effort to harass and intimidate me and my firm. I base my belief on the following. Investigator Jessica Santiago was caught on tape informing my former client, Geraldo Garcia, that she was working for an attorney named Marcy Croft at the law firm of MG Legal PA. Ms. Croft is an attorney in Jackson, Mississippi. Ms. Croft advertises herself as a member of Team Rock. Ms. Croft advertises that she has become actively involved with criminal justice reform and prison reform alongside Rock Nation's philanthropic arm, Team Rock. Rock Nation and Carter are synonymous. Carter is the founder and chairman of his entertainment company, Rock Nation. Carter's attorneys, Alex Spiro of the Quinn Emanuel law firm, and Ms. Croft have worked alongside each other for years. Oh, let me see. Yes, for years representing Rock Nation and Carter, including Team Rock's criminal justice reform efforts. This conduct by the purported investigators and those they work for has resulted in several frivolous lawsuits against myself and my firm. My firm has filed several cases of barratry on behalf of our former clients who were offered money to file a claim against us. And these cases detailed the illegal activities of the investigators and those behind them. Check out the playlist because it's all in there. Based on the foregoing and for the reasons set forth in the accompanying memorandum of law, the Rule 11 motion should be denied. I declare under penalty of perjury that the foregoing is true and correct. Whew. All right, so that was Tony's declaration. Here is his opposition. So, pretty much, the declaration kind of said exactly um why he's opposing, because mind you, there was two things. Alex Spiro was trying to say that the client wasn't properly vetted and that Buzbee was not part of the Southern District of New York in order to actually practice law in that district. um Let me see. So his argument is that Carter's lawyers do not and cannot show that the Buzbee investigation wasn't adequate. None of the factual issues raised by Carter's lawyers justify sanctions. The second argument is that Carter's motion should not be denied because it seeks to evade Rule 12's requirements of impermissibly avoids discovery. And the third argument is that Carter's lawyers should be ordered to pay plaintiff's attorney fees for opposing this frivolous motion. So he's kind of countering and say, hey, look, you doing all these filings for no reason. Now the judge had already told you not to be sitting up here filing and wasting judicial resources with all these crazy pleadings you're submitting. So since you want to waste your time, my time, the court's time, let's go ahead. Let me file sanctions on you. How about you pay my attorney's fees and my plaintiff's attorney's fees? How about that? How about that? Um, Let me see what the preliminary statements see. So, plaintiff and her counsel, Anthony Buzbee and the Buzbee Law Firm, respectfully submits this memorandum of law in opposition to the motion to the of defendant Sean Carter under Rule 11 of the Federal Rules of Civil Procedure to dismiss plaintiff's amended complaint and to award him monetary sanctions against Buzbee. Now, it's 29 pages. I'm not going to go through this. I am going to just point out the highlights of this memorandum. Preliminary statement. Carter's motion amounts to an outrageous and unprecedented attempt to silence a plaintiff who alleges that 24 years ago, when she was 13 years old, defendants Carter and Combs raped her. Carter's celebrity status does not entitle him to special treatment by the courts and certainly does not to on the mere say so of his lawyers, as this court has recognized. uh Kasowitz declaration, I have not. Oh yeah, so the declaration, so Trump's go-to attorneys, the ones that Busby just hired, they also submitted their declaration and they pretty much let him, like, they went in on Alex. They went in. They say, look, the court is not going to fast track this process, this litigation process, because you, Alex Spiro, is demanding it. And I'm sure Jay-Z is putting pressure on Alex. But last night I figured out why. It's not in regards to the Jane Doe, y'all. It's the John Doe case that he's scared of. It is the John Doe case that Jay-Z is afraid of. I'll wait till everybody catch on, and then we could come back and reconvene, cuz not a lot of people don't realize that John Doe demand letter. That's why. So if Jay-Z goes after, if he shuts down this case, then that shows intimidation to the John Doe and whoever else came forward. Pay attention, y'all. Relying solely on what his lawyers say are inaccurate detail in plaintiff's account of this horrific assault, Carter asked this court to ignore the federal rules of civil procedure and, as a sanction for what his lawyers falsely say was Busby's failure to investigate, summarily dismiss plaintiff's well pleaded first amended complaint in its entirety, which would run roughshod over her right to take discovery, and prove her claims before a jury. Even assuming arguendo that plaintiff misremembers details from 24 years ago, that is no basis for invading the requirements of Rule 12 by dismissing her First Amendment complaint under Rule 11 based solely on purported factual disputes concerning those details. This is especially true whereas here the purported factual disputes concerns details arising solely from the memory of a victim. Here, a child victim of SA, which it is well established typically causes memory lapse. In fact, Carter's lawyers themselves got flatly wrong one of the details they falsely claim undercut plaintiff's claim, asserting that at the time of the grape, Carter's co-defendant Combs did not own the house where the sexual assault may have taken place. In fact, Combs did own the house. Oh, it says see infra at pages 17 and 18. Let's go to 17 and 18 right quick. Hold on, let me see. Oh man, I think it's another part that I have to download. That's okay. We'll get to that. I'll probably do a members on that. Carter's lawyers' purported certainty about what happened to plaintiff is thus utterly unjustified. The NBC report, on which they principally rely itself, acknowledged that its purported findings do not necessarily mean the allegations are false. That acknowledgement alone, under applicable law, removes any possible justification for Rule 11 sanctions here. In any event, when stripped of their salacious rhetoric, Carter's lawyers challenge plaintiff allegations and recollection regarding watching the MTV VMA Awards show on a jumbotron, speaking to limousine drivers during the show, the location of the after party at which she was raped, speaking to a celebrity at the party, and plaintiff's father picking her up after she was raped. After shown further below, none of those purported challenges are meritorious, sorry, and none come close to proving, as they must justify any Rule 11 sanction, let alone the most drastic sanction of all, dismissal, that Carter did not grape plaintiff, or that, as Carter's lawyers also falsely say, Buzbee did not sufficiently investigate and was not permitted to rely on plaintiff's unequivocal recollection that Carter raped her. Pretty much what this man is saying is the same way you're claiming that I did not properly vet my client to see if she was telling the truth. You didn't do your due diligence to see if she wasn't telling or telling false, not telling the truth. Where is your supporting documentation? What can you prove? How can you disprove her? How can you discredit her and you haven't shown anything? As the courts have made clear, Rule 11 sanctions will be imposed only in extraordinary circumstances. Let me see. Here, there is no circumstances at all, let alone extraordinary circumstances justifying sanctions against Buzbee. In fact, it is out of judicial concern for encouraging zealous advocacy that the courts maintain a high bar for establishing a Rule 11 violation. But over the top, zealous advocacy is precisely what, as this court has also recognized, Carter's lawyers are engaging in, of which this motion is the latest and worst manifestation. In the declaration with Kasowitz, they stated that Carter's lawyers' relentless filing of combative motions containing it's inflammatory language and ad hominem attacks is inappropriate, a waste of judicial resources, and a tactic unlikely to benefit his client. This is what Judge Annalisa Torres told Alex Spiro. This is not going to benefit Jay Z if you keep doing this. Contrary to Carter's lawyer's basis assertions, Busbee included the allegations against Carter in the First Amendment complaint only after an investigation, including numerous interviews of plaintiff and vetting of the information plaintiff provided. That more than satisfies Rule 11's requirements. On the other hand, Carter lawyers' motions, which they filed even in the face of this court's discouraging them from doing so, is nothing more than an improper attempt to intimidate plaintiff and her counsel and is factually and legally meritless. If anyone has violated Rule 11, it is Carter and his lawyers who, under Rule 11(c)(2), should be sanctioned by awarding plaintiff and her counsel the attorney fees and costs incurred in having to respond to their motion. Mm. All right. Now we're not going to go through this because his declaration actually kind of summed it up. But in all, what they're saying is you can't use the NBC interview because, as they stated before, just because they did their due diligence and they have certain information does not mean that her allegations are false. So stop using the NBC as a way of saying that that the client's claims are false. Stop using that interview because they clearly told you that just because we did our research does not mean that she is telling a lie. They stated that. On top of that, they're talking about the procedural history. They're talking about how Alex Spiro has consistently filed pleadings from from the day that Buzbee added Sean Carter to the complaint. He has been on a whirlwind of filing frivolous, non-meritless pleadings, trying to get this case thrown out and trying to get Busby sanctioned. It was a vendetta. That's why I've always said from the beginning they were doing too much. They were absolutely doing too much. Um, so like I said, I'm not gonna go through all of this only because I'll probably do a members to kind of go through all of this. But all in all, he is opposed to hold on, let me see. I'm reading something. I just seen something that I claimed da, 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 da. Oh yeah, they're talking about the limousines because they're saying that she couldn't have gotten to the limousines because of the police barricades, but there was a limousine area that was parked, and that's where she approached them at. Mm. Oh, this is interesting. Third, with respect to plaintiff's allegations that the party at which she was raped took place at what she believed to be a large white residence with a gated U shaped driveway, Carter's lawyers make the irrelevant argument that photographs show that he attended a party at the nightclub in New York and Combs was photographed at the Lotus Club as well as another establishment in New York City. However, even in the NBC report, on which Carter heavily relies, conceded that it is not clear what time those images were taken or if Combs and Carter attended any other after parties. In short, that Carter and Combs attended one or more parties does not mean they did not attend the party at which they raped plaintiff. Carter lawyers also argue that public property records confirm that Combs did not own a residence at the time that matches plaintiff's description, pointing to a property records for 40 Hedge Banks Drive in East, which purportedly reflects that Combs did not own his residence in 2002. You know, what? Let me tell y'all something. I feel like I need to upgrade. I don't know, maybe I do need to become an attorney because I sat here and I told you guys. So that house that I showed y'all, I did it on a live and I also did it on my Instagram. So 40 Hedge Banks is in East Hampton. It's the big white house with the U-shaped driveway. Now, from Radio City to this location, it would have been a 2-hour drive. But then we have to think about her recollection when it comes to time because she is autistic. Now, people are going to be like, da 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 da. speak to me about the John Doe case, and then you speak to me. I can speak to you about the Jane Doe and her recollection about that because, yeah. But yeah. So Diddy brought 40 hedge banks actually in 1998. Let me keep reading. Um, However, this argument fails for at least two reasons. First, plaintiff does not allege that the home she was taken to was owned by Combs. Oh, I ain't never thought about that. But in any event, Carter's lawyer's representation to the court that Combs did not own 40 Hedges Bank Drive in 2000 is plainly false. Property records reveal that Combs was first listed on a deed for 40 Hedge Bank Drive on March 13th, 1998, and that he or a company owned by him owned the property until selling it in July 23rd, 2020. In fact, Combs' notorious white parties, which Carter often attended, were held at this residence beginning in 1998, including in July 2000 and just 2 months before the grape and in the following years. Oh, ooh, this is some good tea. Fourth, with respect to Carter lawyer's argument that musician Benji Madden was not in New York on the night in question, the First Amendment complaint does not identify any of the celebrities plaintiff spoke to at the party. Rather, the First Amendment complaint merely alleges that plaintiff recognized many celebrities and talked to several of the celebrities she recognized. Carter's argument stems not from what is alleged in the First Amendment complaint, but from a post filing interview plaintiff gave to the NBC News reporter. It is utterly irrelevant that plaintiff may have subsequent misremembered that Madden was one of the celebrities she interacted with, especially given that the First Amendment complaint did not identify any of the celebrities plaintiff spoken to, and her misremembering, if that is what it is, in no way renders her recollection of the traumatic night not credible. So, in law, you got to stick with what is in front of you. If the first amended complaint states something, or a complaint states something, you can't go outside of that. And that's a very good question. I mean, not a question, a very good statement that Buzbee put in here. It does not identify any other celebrities. It just said that she spoke with several celebrities that she recognized and never mentioned Benji. She only mentioned Benji in the NBC interview, but that interview has nothing to do with the content in the First Amendment complaint. Lord Jesus have mercy. Oh, fifth. Carter's lawyers take issue with plaintiff's allegations that her father picked her up from a gas station shortly before dawn, the morning after she was raped, on the grounds that NBC reported that her father does not recall doing so. Do you know, in the First Amendment complaint, nothing mentions the father? They're only taking their information from what was told in the NBC interview. Pay attention. Given that this occurred 24 years ago, it is not surprising that the father may not recall a specific drive to pick up his daughter. Moreover, as plaintiff stated in her interview with NBC, and reflecting a reticence not uncommon in sexual assault victims, she never told her father or anyone else about what happened to her at the party. Rode home in silence. He didn't ask me what happened. He didn't ask me what I did or where I was. She told NBC News she never told anyone about the alleged assault or wrote it down in a diary. Indeed, given the passage of time, it is entirely possible that her father is simply mistaking and recalling the time he picked up plaintiff up once picked plaintiff up in the middle of the night, or having been a local drive. So pretty much he said all of this to say, hey, look, none of this, none of this is satisfying to the high bar to impose sanctions against me. None of the challenge allegations could possibly render plaintiff's claim utterly lacking in factual support as is required for sanctions, particularly in light of the court's duty to resolve any and all doubts. Child, now here's the crazy thing. I'm looking at this footnote. Where did this footnote 12? So this is talking about how he transferred his property to a company, 40 Hedges Realty, at the residence beginning in 1998. Then the footnote here says, indeed, as reported by the New York Post, Combs was fined $2,000 for violating the town of East Hampton's noise ordinance during a 4th of July party at his property in 1999. So he's known to have parties at that house in the Hamptons. Mm. Child, 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 child. So that's it. So in conclusion, Busby is saying uh Busby is saying that based off of Jay-Z's or Alex Spiro's motion to sanction him, there is no supporting argument that the court should grant this motion and sanction Busby. They're making all of these claims, like we just heard about the house and about the father's story and about her story. The defense counsel, Alex Spiro, does not have anything to support what he's trying to sanction Busby for. He has nothing. He has absolutely nothing. So now, once again, you are wasting the court's time and the resources. So since you are doing that, Busby say, hey, judge, please deny his motion and actually grant my plaintiff fees, cost of court, as well as attorney fees. Point blank, period. That is it. That is it. Y'all, this is going to be a lit 2025 against Jay-Z and Busby. Busby is not backing down, and I need to check the other cases. So there's so many things that's going on. You got the Jane Doe case that Busby is on. You got the case where Jay-Z is suing Busby. And then you got the cases that Busby filed against Rock Nation and Jay-Z for the investigators trying to pay people to file a lawsuit against Busby. So it's on and popping, and Busby is not backing down. But y'all let me know what y'all think in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed, and I'm out. Bye.